Good afternoon, everyone. Thank you for joining this webinar about the use of social media in community supervision. In recent years, social media has emerged as an important topic for community supervision policy and practice. Social media can be a valuable tool to help connect supervising officers with the activity of offenders on community supervision. However, with this opportunity also comes challenges. Today's webinar will share emerging research, policy, and practice information. I'm Heather Tubman-Carbone, and I oversee technical assistance for the Corrections Portfolio at the Council of State Governments Justice Center. I will be your moderator today, and I'm excited to introduce our presenters. Joe Russo is a researcher with the University of Denver and has supported various National Law Enforcement and Corrections Technology Center programs, a component of the National Institute of Justice, over the last 18 years. Joe holds a master's degree in criminal justice and has chaired the American Probation and Parole Association's Technology Committee since 2001. Joe also led a recent effort to develop an APPA issue paper on the use of social media in community corrections. Les Schultz is a probation director in Brown County, Minnesota. Les has a master's degree in criminal justice and is an adjunct professor at a university in Minnesota. Les has been involved with APPA for over 20 years and was recently elected to the executive board of APPA as a regional representative at large for Minnesota, Wisconsin, and Iowa. We're also joined today by Adam Matz, a research associate with the American Probation and Parole Association, an affiliate of the Council of State Governments. Adam is a doctoral candidate in criminology at Indiana University of Pennsylvania and has authored various publications on interagency information sharing, police, probation, and parole partnerships, occupational satisfaction, and gang member recidivism and assistance. Thank you to Les, Joe, and Adam and APPA for co-presenting with us today, and thanks to all of you on the line for joining the webinar. Before getting started, I'd like to briefly talk through a couple of housekeeping items about how today's webinar will work. If you encounter any technical or audio problems during this webinar, please call WebEx Technical Support at 1-866-229-3239. Please understand that there are some technical issues you may not be able to resolve, and for this reason, we're recording this webinar and we'll share it with you via a link in an email shortly after we close up today. We'll start off the webinar with some background about the Justice Center and APPA, and then we will explore why this topic is so important. We'll dive into greater detail about how to establish policies around the use of social media from a variety of perspectives, including administration of social media content, setting expectations for appropriate employee personal use, and investigation and supervision standards. Our presenters will also share one jurisdiction social media policy and discuss some of the issues agencies may encounter as they incorporate social media standards into their operations. We will wrap up with a question and answer session. Anytime during this webinar, you can ask a question by typing it into the Q&A panel at the bottom right-hand portion of your screen. This also includes any technical questions. If you are having trouble with sound or maybe some small glitches that we might just be able to provide some insight and help you out with on the spot, we're happy to do so. We'll reply to the technical-related questions as we go. For the content-related questions, we will keep a running list and address them all at the end of the webinar. The Justice Center is a national nonprofit organization that serves policymakers at the local, state, and federal levels from all branches of government. Staff at the Justice Center provide practical, nonpartisan advice and evidence-based, consensus-driven strategies to increase public safety and strengthen communities. Within the Justice Center, the National Reentry Resource Center is funded by the Bureau of Justice Assistance, and we provide support to Second Chance Act grantees and to the broader field. We're constantly adding new content and resources to our website, and we send out a monthly newsletter that provides information about the latest research, funding opportunities, distance learning events, and other news about reentry. To sign up for the newsletter, please visit the link on your screen after today's webinar. The American Probation and Parole Association is also part of the Council of State Governments. APPA is a member association that represents community corrections professionals in all levels of government, in the public and private sector, and in tribal agencies across criminal and juvenile justice. APPA is widely regarded as the voice for pretrial, probation, parole practitioners at all levels, and members also include educators, volunteers, victim service providers, and interested citizens. APPA regularly provides training and technical assistance to folks in the field, including a journal, up-to-date research, and information clearinghouse services, and advocacy efforts. APPA is also widely known for its training institutes and leadership institutes. And now I'm going to turn it over to Joe Russo to talk a bit about APPA's foray into social media vis-a-vis their technology committee.
Thank you, Heather. By way of history and an introduction to this webinar, I wanted to talk very briefly about how APPA got involved. Basically, back in 2011, Carl Wicklund, the executive director of APPA, contacted the technology committee and made it known that he was being approached by many agencies about this issue of social media. Agencies were beginning to explore social media as a way to investigate and supervise those persons under supervision, but there was very little guidance available, and he tasked the technology committee to develop an issue paper to help the field address some of these issues, understand the importance of social media as a supervision tool, understand the potential of the information and how it could be used, and finally be able to develop guidelines to ensure appropriate use of this new and emerging tool. To support that effort, APPA facilitated a survey of its membership to establish some baseline information about how social media is currently being used out in the field. And that helped inform the issue paper on the use of social media in community corrections, which was approved in 2014 by the APPA Board of Directors. That issue paper, for those out there who are interested, is available on the APPA website. So basically, what is social media? Folks should know that social media and social networking is not necessarily a new concept. Back in the 1970s, bulletin board systems such as Usenet allowed people to share content and ideas. In the 90s, this evolved into sites like The Globe and 6 Degrees. Currently today, most popular sites include Facebook, Twitter, LinkedIn, Instagram, and so on. So it's been a continual evolution of social media and social networking, and we shouldn't be confused to think this is a new phenomenon. It's simply an evolutionary process. So what exactly is social media? In a nutshell, it's a variety of web-based channels dedicated to interaction, collaboration, and content and idea sharing. A key distinguisher between social media and traditional web is the ability to interact with others anywhere, anytime. Why is social media important? Community corrections is essentially about relationships and communication. That said, the way in which humans are communicating today has changed radically and rapidly. Traditional forms of communication, such as letters and telephone calls, are rapidly fading. If you have a teenager at home and you try calling them on the phone, you likely won't get a hold of them. But if you can text them, your chances of reaching them are much greater. And that's the reality that we live in today's world. Further, print media is declining. For many people, particularly younger people, social media is the preferred method of communicating and receiving news information. Some statistics on your screen from the Pew Research Center show that 71% of all teens use Facebook now. In a larger context, 95% of all teens were online last year. Among the social media sites in particular that are most prevalent, Facebook remains the most popular, although Instagram and Snapchat are rapidly gaining in popularity. It's important to note that young people aren't using just one social media site or platform. 71% of teens use more than one platform, so they're using a broad base of platforms across different types of media platforms as well. Finally, it's important to note that mobile devices are driving increasing use of social media. In the past, if we wanted to use social media, it was from a desktop, either in our office or in our home study. But now everyone carries a computer with them, whether that be in the form of a smartphone or an iPad. We all have computers that we carry around with us, and so we like to keep in communication, keep in touch, and use social media. So literally, we're using social media more and more to connect with people anywhere, anytime. Social media is not just for the young people. Again, the Pew Research Center reports that 87% of adults were online in 2014. And an interesting statistic that I wasn't aware of, over 56% of adults 65 and older use Facebook. So again, it's not just for young people, it's not just for young adults, but it's really infiltrating all of society, and all of society is using social media more and more. And again, similar to young people, more than half of adults use more than one social media platform to interact with folks. So why should we care? Why is this important for community corrections? Well, with respect to social media, the people that we supervise are no different than people in a larger population. Supervisees use social media just like everyone else. They have a physical presence and they have a virtual presence. As we know, the virtual activity can reveal much about a person, their proclivities, their preferences, and online activity has very real impact on the real world. Crimes are planned and perpetrated online. Cyberbullying and stalking are common occurrences. The bottom line is, if community corrections is serious about changing behavior in this day and age, we simply can't ignore a supervisee's virtual life, which includes their social media activities. This next chart shows the Conversation Prism. Basically, it's a diagram that was put together to represent the variety of social media sites available by classification. And the classifications that were offered reflect things like business, photographs, pictures, video, location services, enterprise. You'll note that at the center of the prism is the word you, Y-O-U. This is important to note because social media is very me-oriented. It's all about sharing what you're doing, when you're doing it, sharing more and more information. Social media encourages sharing, sometimes inappropriate or oversharing. And this is important for community corrections as we can leverage that fact. And we'll talk about that more as we move through the presentation. So using social media in community corrections, how can we leverage social media? Three basic elements: pre-sentence investigations, post-conviction, and absconder or fugitive apprehension. At the early end of the beginning of the process, when agencies are performing pre-sentence investigations, it's very important to use social media to get a better picture of the person before the court. An in-person interview will reveal some information, some background checks will reveal other information. But as we all know, people have a tendency to share information online via social media that they may not reveal in other formats. So using social media, we can gather information about whether the person is truly remorseful for the behavior that led to the interaction with the courts. Do they have gang activities? Do they display assets via social media posts that the court may not be aware of, and so on. When we get to post-conviction supervision, social media can be used to determine compliance with conditions of supervision, such as, are they staying within the geographic boundaries established by the court? Are they maintaining proper associations? Are they hanging out with gang members or criminal associates, and so on? And finally, it can be used to monitor life status, which could be something like drug or alcohol use, but it could also reflect other aspects of what's going on in the supervisee's life, such as a change in status in a job situation, a loss of a job, change in housing, death of a family member, things that might be going on in the supervisee's life that would be important for the supervising officer to know, which may not be known in any other way. The offender may not disclose some of this information directly to the officer, and social media can be a way to get that information, obtain that. Finally, and this is probably the most prevalent use of social media in community corrections as a supervision or investigation tool, but the ability to use social media to monitor the whereabouts of absconders or fugitives. Very often, when an offender absconds from supervision, they will maintain contact on Facebook or other social media sites. So it becomes fairly easy to track that offender as they move about. The second aspect of that application is that social media is used by some agencies to solicit help from the public, and they'll post information about absconders and ask the public to help them with information that leads to their whereabouts and apprehension. A less known application or emerging application might be the use of social media as a situational awareness tool. This primarily speaks to officer safety issues, and social media activity may reveal information about the supervisee and or the environment that's important to the officer's safety during a field visit. For example, does the offender post information on Facebook that indicates that he is trained in martial arts or has some other specific training that the officer might want to know about before entering the home? Are there animals in the home, and so on? Again, information that may not have previously been disclosed in a face-to-face interview, but the supervisee may have disclosed this inadvertently disclosed it through Facebook or social media postings. On a broader perspective, there are technology out there, tools out there that help agencies analyze social media activity on a broader level. So we can use these tools to monitor public sentiment. Receiving postings on various social media platforms that indicate anti-law enforcement sentiment in a particular area, neighborhood. Again, this would be good information for an officer to have before they enter a particular neighborhood to do a field visit. Types of information shared, more than you'd think. For folks out there who use social media to monitor offender behavior, it won't be a surprise. But for the general public, supervisees overshare just like everyone else. Researchers who study social media note that there's a disinhibition factor or effect of expressing yourself on social media. Essentially, you're not face-to-face with someone who can immediately react and respond to what you've just said or what you've just shown. So there's an invisibility effect here that allows you to overshare. Further, what's going on in society is that our identities are more and more based on online activities, particularly among younger people, and even professionals who use sites like LinkedIn. The emphasis on these sites is who are you, what do you have to share, how many followers or connections do you have, and so on. So it's very much about, about you and what you're about. So some specific information that is shared include geographic information, not only where they were or where they are now, but folks will share information about where they're going. And of course, if it's a situation where a supervisee is not allowed to go out of a jurisdiction or a particular boundary, that information could be very, very relevant. We've talked about relational information, who they associate with. Again, this information may be shared on social media, but not otherwise. And real-world activities, what they're doing at a particular time, whether it be criminal or non-criminal, but behavior of note. For example, drinking or not reporting for work or blowing off work, activity or behavior that would be of interest to a supervision officer. Again, not otherwise easily known. For some supervisees, obviously, any internet activity, including social media activity, is a violation, and that refers mostly to sex offenders who have those special conditions. So some examples of supervisees who've gone wrong and overshared. The image on the left refers to a woman in Michigan who was on probation for a DWI case. She had been drinking and was called in for a breathalyzer the following day, passed the breathalyzer, and thought it was appropriate to celebrate her success and her good fortune via a Facebook post. Unfortunately for her, there was a police officer in the area who was monitoring the social media activity, saw the post, and notified the woman's probation officer. The probation officer then called the woman in for a breathalyzer, or actually called her in for an ETG test. And the probationer hung up on the call and was subsequently charged with failure to comply with an order. The other images show, folks using drugs, possession of weapons, just examples of things that supervisees will post that's not in their best interest, but obviously is for the betterment of justice and public safety. So an example of why it's important to monitor what's going on social media. This other example is came out of Oregon, dubbed the "Catch Me If You Can." Probationer basically was very upset with the justice system in Oregon, decided to post a rant about the inefficiencies and injustice that he experienced out there, and then subsequently left the jurisdiction. And as he left the jurisdiction and bounded across the country, kept taunting officials with various signatures, like the one who got away and "Catch me if you can," and "I'm in Alabama," and so on. Eventually, this particular probationer posted a photograph of the sonogram of his unborn son in Alabama, and the sonogram had the name of the hospital right on it, so it led officials directly to the county in Alabama where the offender was, and a warrant was issued, and he was subsequently picked up and returned, and is now serving over 2 years in prison. So back to the question about what do they share, more than you would think. There's a tendency to overshare, and in our line of work for supervision of offenders in the community, that's not necessarily a bad thing. So back to the survey. I mentioned the survey of APPA members earlier in this presentation, and I wanted to touch on some key points in that resulted from that survey. Basically, 66% of the respondents indicated that officers in their agency use social media as part of the supervision process. And that broke down into two basic types of monitoring. And those are apparent or overt use, discrete use, covert use, and general internet monitoring. And this chart kind of breaks down the key differences between the different types of monitoring and some of the survey results in terms of how prevalent that particular technique was used. Starting at the top, apparent or overt use is the most common. 91% of the respondents who say they use social media to monitor activity use this approach. And this is the least intrusive approach. Here, the officer does nothing that an ordinary citizen couldn't do. They're not obscuring their identity as a law enforcement officer, as a community corrections representative. They're simply viewing information profiles that are public and available online to anyone. And again, this is the most common form. Down the chart, discrete use is a little bit different. There is no direct interaction with the supervisee, but the officer makes a deliberate effort to obscure his identity and the identity of the agency. So they may use a fictitious identity. They may anonymize the IP address so it can't be traced to the law enforcement agency, but there is no, again, no direct interaction with the supervisee. Further down, covert use is the most intrusive method that we've identified. This is where an officer creates a fictitious identity for the purpose of directly interacting with the supervisee. The IP addresses are anonymized, so they can't be traced back to the agency. And this basically boils down to other undercover work. The officer is creating an identity, a fictitious picture, a backstory, and is trying to contact the supervisee, interact with the supervisee to determine if there's something of note that's going on in terms of behavior or criminal activity. This is one of the most important types of techniques that require specific training because of the nature of the type of work. And 29% of the respondents indicate that they use this type of method. The last option is general internet monitoring, and this is kind of an offshoot from the others. It's kind of different in that it doesn't relate to social media monitoring directly, but more of an internet monitoring approach. So they're using internet monitoring tools to determine if the supervisee has been on social media because there's a condition that prohibits any internet use. And for that type of technique, 29% of the respondents indicate that they use this approach. Some additional survey results of note. 33% of officers periodically require the supervisee to come to the office, log on to Facebook, for example, and show the officer what's on their profile. So open view of profile in the officer's presence. 28% of the officers report friending supervisees so they have access to private pages. The need for guidance. Again, as you recall, the impetus for the issue paper for APPA was the fact that more and more agencies were looking at this, looking at social media as a way of keeping tabs of their offenders in the community, and a way of understanding what's going on with these individuals. But there was a lack of guidance, a lack of policy. To that point, the survey revealed that 44% of respondents indicated that their agencies use social media to supervise offenders in the community. Yet 66% of respondents indicated that officers in their agency use social media to supervise offenders in the community. And this disconnect between the 44% and 66%, it might be due to sampling error, but we feel like it's more due to individual officers using social media, absent of agency guidelines and perhaps even approval, specific authority to use social media. And it's not a criticism. Officers are using whatever tools they have available to do the best job they can, but we think it illustrates the need for good policy and procedure around the use of social media. For those agencies who use social media, per the survey, only 26% had a policy. And in every case, those policies referred to what we called administrative issues. So they were policy related to how the agency uses social media as an outward face, how individual employees should use social media in their personal lives, what's okay and what's not. There was no policy that focused specifically on how to use social media as an investigative or supervision tool. We understand that some jurisdictions are developing policy in this area, but we haven't been able to find one that's completed and available. As agencies start to consider using social media as a supervision tool, they may benefit from what other segments of the criminal justice system have already done. The Global Information Sharing Initiative developed some guidelines on developing policy for social media around the use in intelligence and investigative activities. This was developed specifically for a law enforcement function, and given the inherent differences between law enforcement and community corrections, some of these elements may be more important than others, but in a general sense, these are good elements to consider as community corrections agencies develop their own policies. In general, if your agency wants officers to monitor social media activity, we need to provide them with guidance and clear expectations. It should be articulated as to why, when, and how social media monitoring is permitted. And the general guiding factor is purpose. Why are we doing it? Why are we examining social media content and activity? So going down the list, obviously social media resources should be used in a manner consistent with laws and agency policy. Here, the agencies need to focus on what is appropriate use for their jurisdiction, for their community, not just what is legal, but what is right and what they feel is appropriate. For example, some agencies might feel that establishing a fictitious identity to interact with supervisees is inappropriate. Others might feel differently. Again, every agency has to make that decision for themselves and establish guidelines so that their officers understand where the boundaries are. Point number 2, officers need to know in what cases they can use social media, what tools are authorized to monitor social media, and so on. Point 3, we need to clearly identify levels of authorization. So what types of social monitoring techniques are appropriate in what case? When is it okay to use overt monitoring? When is it okay to use covert monitoring? What level of authorization is required? And further, for what length of time? Is it a blank check where you can use social media for this particular supervisee until you determine otherwise? Should it be time limited, and so on? Again, just issues for agencies to consider as they develop policy. Number 4 relates to how your agency will authenticate the content and context of the information posted, whether it's pictures, photos, video, or text. Again, this might be more important in a law enforcement setting, but how do you know the profile was created by the supervisee and not someone else? How do you know the image shows a marijuana cigarette versus a tobacco cigarette, and so on? there are various ways of authenticating social media content, and again, some of this might be more appropriate in a new prosecution setting to a post-conviction setting, but things for agencies to consider certainly. Number 5 relates to evidence in general. Social media evidence is like any other evidence, whether it's physical evidence or otherwise. We need guidelines as to documentation, how we should document this evidence, how it is to be properly stored and retained. Item number 6 is important, relates to establishing guidelines for off-duty use of social media. So an officer is off-duty and they want to monitor social media activity of one of their clients. Is that appropriate? What are the guidelines around that? If and how should personal equipment be used? The officer wants to use his own personal computer at home to do this activity. Is that okay? Is that an issue? If evidence needs to be brought into court, is the officer's personal information then subjected to discovery and so on? Similar issues to doing general computer searches as well. And finally, item number 7, identify procedures for gathering and disseminating the information. So if you're gathering information about social media, personal identifiers, we need guidance about how that information should be shared, how to limit that information so it's not overly shared with agencies or others who don't need that information. Some policy resources that you should be aware of as you're developing policy or thinking about policy. The International Association of Chiefs of Police has a Center for Social Media. Their website is listed there. Again, they have a number of issue papers, model policies. They're going to be directed towards law enforcement, but it provides a good base that community corrections agencies can use to tailor policy to their own needs. And again, the Global Justice Information Sharing Initiative that I referenced earlier, there's the citation online where you can get more information on that. Some implementation issues that came out during the survey. One of importance was the issue of gathering social media identifiers. So password profiles, usernames, passwords. Only 34% of agencies who responded indicated that their department collects identifiers. So agencies, if they're serious about monitoring social media activity, they have to be vigilant about getting the profiles up front and also about regularly getting those updates. As offenders or supervisees might create new profiles, we have to have mechanisms of obtaining those identifiers as we go. Obviously, it's not a one-time activity. Access to the Internet. 12% of respondents indicated they have no access to the Internet at all at work. And obviously, if you want your employees, your staff, to monitor social media activity of their clients, they need access to the Internet. There's a movement across the country in some states which is limiting or banning public employee use of social media on duty. So if these initiatives are moving forward in your jurisdiction, we need to make sure that the powers that be understand that there's a legitimate purpose for community corrections agencies to have access to social media while on duty. The last implementation issue refers to computers at the community corrections office and the importance of standalone computers with Internet access. Because of the potential for introduction of viruses and malware, any social media investigation, any searches should be done on a dedicated computer, so one that's not linked to the network, so that you limit the potential for introduction of malware to an entire system. Per the survey, only 5% of agencies had dedicated computers for social media monitor activity, so obviously that is a concern. Moving on to training issues, majority of respondents per the survey did not receive any sort of training. Only 30% report receiving some form of training. Of that number, 21% report receiving basic training, or I'm sorry, specialized training. That's beyond the basics. So the key takeaway here is that if you're going to be doing covert investigations, undercover type investigations, you need something that's beyond the basics of social media investigations and monitoring. You need specialized training in that area, and there is training available. Some training resources that are out there are listed in the next slide. FBI provides a computer forensics laboratory for that type of activity. Fox Valley, IACP, Search, and others all provide training in the area of social media investigations that may be valuable to your agency as well. So in conclusion, an understanding of a supervisee's social media activity and internet use in general can be very important to the supervision process. Before engaging in and monitoring activities, agencies should establish policies and procedures to guide officers and provide the appropriate level of training. With all of these things in place, social media monitoring can be a great benefit to agencies in their mission to enhance public safety. And I'll turn it over to Les now.
Good afternoon, everybody. I'm looking at our attendees, and we have 354 attendees on a Wednesday afternoon learning about policy. Hopefully everybody's got a little bite-sized Butterfinger in front of them to make it through, because I have mine. We're going to talk a little bit about the actual development of a policy here in Brown County. A little demographics. Brown County's in southern Minnesota. We're a smaller county. I'm very blessed to have wonderful probation officers here who really wanted a policy on this topic because it was becoming an issue in our department, with probation officers wanting to know what offenders were doing on social media. So some at home, at night, some here in the office were looking at offenders' websites and social media sites and trying to find out what they were doing or what they were up to, or they were being told by other people that, hey, did you see what Johnny did on their website? So again, Brown County is a smaller community, so it was a little bit easier for us to develop a policy primarily because of our location being a little bit smaller, and we were in a large metropolitan county, but we still had obstacles. And what they've asked me to present on is actually the policy that we wrote and the obstacles that we went through, so that those of you in the audience that are wanting to develop a policy, and I'm assuming that's more than likely why you're here, you'll have at least somewhat of a template to go by. Looking back now, after we're hearing what APPA has done and their suggestions that Joe just went through, certainly would enhance the policy that we wrote and would make it a lot stronger. So we have some work to do on the one that I'm going to show you today, but at least you'll have a template to take a look at. So and my slide is not moving, Jan. There we go. A couple little humor things, because again, policies can be a little boring. So just a little bit of humor here. So why did staff want a policy? Again, these are the areas that they wanted to have some guidance on and some guidelines on. One would be just on the general overuse of social media. What could they, obviously they're worried about what they could get in trouble for. Who do we report violations to? What is considered a violation? And can we be covert? Several of our probation officers wanted to go that direction. So back in 2012, we were looking around trying to find some policies that we could start on. And again, APPA was starting to work on their social media policy, but we didn't have a final product yet. So we went out and law enforcement surprisingly does have some social media policies. We were able to collect a few, but they were vastly different than what we were looking for. We also surprisingly found someone suggested that the school to contact your local high school and see what they had for policy. And they actually had one that was helpful for us. So we were able to gain a little bit of information from from the educational folks. So we created a committee of those that really had an interest in wanting to do this. So I sat in on this committee, my assistant director. We took one lead probation officer who'd been around for quite a few years. We had one younger, more tech-savvy type person, and then we took a program staff member. We decided on our tasks that we wanted a written policy. We wanted those concerns that I talked about earlier addressed. We knew that we would have to, once this policy was developed, we were going to have to sit down with our county attorney, who was our legal representative, and go through it. But we also knew that based on some of the information in our policy, we're going to have to deal with HR. For our human resources folks, to make sure we weren't overstepping our bounds and requiring things that we could not do. And as a matter of fact, we did find out that there was a lot of things that we had to address and change. And then finally, because it was an overall policy, we needed county board approval. And then we certainly had to talk about how are we going to implement this policy within our own agency. So we've decided on a timetable, and I'm kind of a stickler on timetables because I like to make sure projects get completed that get started, or otherwise, as most of us know, they can get stalled. So here's the timeline that we took that we thought would work. We figured 15 months, we could have this done, a little over a year. However, we know when we're dealing with legal folks, sometimes things can take longer, and we did get stalled there. So it actually took actually 2 full years before we could implement our policy. So we did start our official policy on January 1st, 2014. We were very happy once we got it done. It had a lot of rewrites and a lot of rewrites and a lot more rewrites. So I'm going to actually go through now and show you what our policy looks like. And at the very end of the presentation, we will put the policy up for you, and you can actually take it, copy it, print it, and cut and paste and do whatever you'd like with this policy. Also, again, just a reminder that if you have any questions for Joe on his information or as I go through mine, feel free to go into that chat box down in the bottom right-hand corner and submit those questions for the end of the presentation, and Joe and I will do our best to answer your questions. So this, what you're looking at now is just simply our general operations policy page. Shows the effective date, and so just the front cover of our policy manual. And this page, the next page, this just starts what was underneath that section, so what our purpose of the policy manual was. And you can see there's some educational material thrown in here by our legal team, and HR wanted some more general information in there. So the purpose, obviously, to establish our position on the use of social media and its guidance for staff and administration, including myself, and any oversight responsibility. The bottom of the page has social media may be used when considering candidates for hire. That actually had probably 3/4 of a page more information in there than that, but our HR and our legal team basically wiped a majority of that out and said less was more, and that social media may be used when considering candidates for hire, and that's all we have now. And just kind of left it open for the hiring folks to take a look at social media if they had a candidate had a social media site for a probation position or something within our agency, that we are going to look to see what is on their social media site. So that kind of got worked into our policy as well. We did some definitions. I'm not going to go through that here this afternoon, but on the policy site we do have definitions. So when you take a look at the final product, you'll see definitions for this information here. We have 2 sections under the policy and procedure. The first one is the internal sites that we maintain as a probation department. The second part of our policy is staff's use of social media on their own time. And so we'll go through both of those particular sections. So we also talked briefly about how we were going to implement this. And we kind of kept our staff that weren't involved on the committee involved in what we were working on, so it wasn't going to be just dumped on them on a certain particular day. They knew what we were working on as we developed this policy. So staff meetings, we would discuss where we're at with the policy. If we wanted some feedback on certain areas, we would bring it up at those particular meetings. So it wasn't just dumped on them on January 1st, 2014, that they had some knowledge it was coming. They had some idea what the content was. We talked about why it would be beneficial for our department to have this policy. And if staff had concerns as we went through with rough drafts, they would come and talk to one of us on the committee. So the sites that are maintained by our agency had to be approved by me. In other words, nobody could create a social media or Facebook website with Brown County Probation on it without talking to me first. We've decided since then not to create that website, at least at this point. However, in the recent few months, there's been more talk about starting that up again. And again, any site that's sponsored by the probation department here in this department would need my approval before it could be developed and put out onto the public website. And any type of overt social media sites indicate that who we are and what we're all about and have contact information. These are some general rules in our policy that if we do open up a website of some sort, that we're following all the basic rules and technology, that the content is open to public record. Obviously, it's a public site. And that if we're going to open up a site, someone better be managing it and making sure it's meeting all the requirements and rules set by our legal team as well as our department. Our legal team wanted a section, and they're saying that an opinion section is set up, and a lot of these websites have comment sites. Comments are opinions, that somebody also needs to monitor that and to make sure that they're not that there's a comment that comments are not reflective of the department. So that needs to be a precursor underneath the blog site or where you can make comments. And again, we would want to have somebody monitoring whatever is there to have the right to delete topics. So when we talked about creating a website, we also said someone's going to have to be in charge and monitor that on a regular basis. Even if they're on vacation, somebody else then would need to monitor that, because we all know it doesn't take very long before a hot topic can kind of take it on its own life without somebody monitoring that, especially if it's not appropriate. Okay. Some of these things were in red. I kind of highlighted them because they were areas of a lot of discussion with our legal team. And initially the legal folks didn't even want this one in there, but they settled and let it in there at the very end. The staff members should not discuss political activities or promote private business. We all know how tough that can be, especially in our political world. However, we did leave it in there that staff just had to simply leave their politics to themselves and couldn't, hey, I'm opening up a new private construction business, you need some help, come and see me. So we just said we can't promote anybody's specific business. And obviously trademark issues are important. Now we're moving on to the area we're going to spend a little bit more time, and where a lot more of the controversy was in developing this particular policy was our own personal use of social media. As corrections professionals, depending on where you work, and we're, at least in this area, we're seen as probation officers 24/7. We're always on duty. What we say and what we do is reflective of who we are as a department, who we are as a person. So this became really a tough issue with our legal team. And in our HR department as well. So this was some of the information that we came up with about what we could do and what we couldn't do on our own personal websites or acting as a probation officer in public. So again, these are some of the areas of discussion. Department personnel are free to express themselves, and this took a lot of rewording, trust me, on how speech does not impair working relationship with the department. So I asked for a working definition of that. What do you impair working relationships? What does that mean? And again, our legal team at the end decided that that was better that they not explain it than they should have a full definition of it in case there ever was an issue. So it's kind of like a case-by-case basis. If something comes up, we're going to take a look at that definition. And when we have the end of the paragraph saying for which loyalty and confidentiality are important, we haven't had an issue, so I've had some questions if we've had any violations. We have not. Staff have been very good at following these policies, but this is the area that we would spend a lot of time on if there was a breach, if there was a particular issue, is did it violate this particular paragraph. The second one is almost the same type of thing. The staff members may not impede the performance of their duties, impair discipline and harmony amongst coworkers, or negatively affect public perception of the department. So they have a bad day at work and they go home and they rant and rave on their Facebook about what a terrible department X agency is and staff are not fair. They're going to violate this policy, and we'll be talking with them in the next working day. Again, these were real tough areas to develop, as most of you are aware of with your legal team, and that darn Constitution. I'm just kidding. Staff members are cautioned that speech on or off duty owes existence to the employee's professional duties and responsibilities, not protected speech, and may form the basis for discipline if deemed detrimental to the department. And then the second one is more of a cautionary note. Department personnel should assume that their speech and related activity on social media sites reflect upon them as a professional in this department. So when we hire new employees now, we talk about this particular area. It's not just something that they're supposed to figure out on their own. We spend some time on social media sites because it is so prevalent now with especially the younger generation on their day-to-day duties. Again, just a caution on confidential information. That's pretty obvious. Again, one of the things that we talk about when we hire new employees. The second category is interesting, and I'm sure all of you or most of you, if you want to Google YouTube and Google inappropriate probation officer websites or videos, you might see some of the things where people have their probation jacket on and they might be consuming a beverage or doing something illegal or just not appropriate. Certainly those folks have been disciplined, and so we obviously have a caution on here for folks as well that they can't be doing that, and we'll come up with some explanations and some scenarios for them. These are some cautions that our legal team came up with. Both of these are really maybe not necessarily policies other than just cautionary type information. That we have a code of ethics, that anything you say on the internet can come back to haunt you. And when I tell kids that their Snapchat pictures are not really disappearing after how many ever seconds, a lot of them freak out and give you that look like they don't disappear, that they can be retrieved. But we also make sure our staff are aware of the same thing, because some don't, some are not aware. Moving on to this particular page, department personnel should expect that any information that they create, that they transmit or download, can be accessed to the department. So we've had some issues in the past when people are on break. They assume that their 15 minutes on their computer, work computer, is their own personal stuff. Well, no, it's not. It is work-related material, and it can be accessed. Same thing with the last category here. Staff are subject to discipline, including termination, if they violate any of these particular policies, and they sign off that they read and they agree to all the policies that we have in place for the particular agency. And again, we've been very lucky. We've not had any issues of any violation, and hopefully we don't for forever, but you know, it's here to protect us in case something does happen, and we all know it can. Our county attorney said that we needed to have something in there just to warn them that slander is out there. You can be sued for slander, so if they would say something very negatively and have some of what they believe are facts around it, that they could be subject to a slander lawsuit in our particular state. And I know it's different in many variety of states, but there's still that potential for being held, someone trying to sue you for false information. So we have that obviously in our policy as well. A lot of the questions that we had from staff is like, when do we tell you, or how do we tell you that that staff person X has put an inappropriate photo on their Facebook? So we kind of developed this particular policy post as far as that they need to let me know the next working day that there's something out there. What I've noticed just in the last couple of years is the probation officers, if there's a major issue, they're texting me as soon as they see something. So again, some of that, it's not call me the next working day thing. It's now. It's the immediacy of our technology and advancements. Joe kind of covered this already in some of his information, but we do have one computer in our agency, and only one, that pretty much any website you want to go to is there, but it's only one. They are blocked from all of our other work computers. So we have one station that they can log in on and check their clients' websites and go in and particularly take a look at what's there. After we wrote this policy and we implemented it, we realized that we were missing some things and some pretty large items. Again, we didn't really have a lot to go on when we developed this. We did the best that we could. But we've now talked about whether or not we could use covert use or overuse or disguised use, and we do use disguised use in our agency. So we are going in. We do have a fake Facebook site. We do not converse with offenders. We go in and look and snoop and snap pictures or take pictures, but we do not converse at all with clients other than trying to friend them or whatever you might want to call it with the different sites. So once we get in there, then, and surprisingly, you'll be shocked, and maybe, I don't know how many of you have tried this, is I bet 90% of the clients accept our friend request just because so many of them need to have that big number of friends. But we were very surprised that, I would guess from what my staff tell me, 90% of the time clients accept that friendship from the make-believe person that we've created. I think we come up with something creative that's stood for PO, or short for probation officer. But a couple staff were in charge of creating that. Not creating anything that's too crazy out there, just a basic normal person. We didn't go too wild with any descriptions or anything of that particular nature. And then the second thing that's not in there is that agents may use data shared by an offender in a violation hearing for investigation and supervision purposes. And by that, we've, in the process of rewriting a policy, and what we'll be doing in that particular area, having a better description of getting second and third opinions on, is this something that would stand up in court or not? Is this something that we need to talk to the district attorney before we add this to the violation report? A lot of times that is the case. It's not enough yet until you get something a little bit better. But it's always nice to get that second and third opinion before we include it into a violation report. So this is just kind of ending my presentation here. Instead of being fired, I prefer to be unfollowed by my job. So a nice little bit of humor there. So I'm going to turn this back now to Heather, who's going to do the question and answer piece for you. And you should start, I think she'll tell you about where that document will be located here. If it's not uploaded yet, it will be shortly before the presentation is over. So Heather, I'm going to bring this back to you.
Hi, Les. This is actually Jan at CSG Justice Center. I think Heather's having a bit of connectivity issues. She was just disconnected. But while we give her a second to dial back in, if everyone can look to the chat box, I'll put a link to both the slides and the document that Les was just mentioning. And here she is. We'll just give her a second to get connected again. So both links should now be on your chat box. Heather, we're still not able to hear you.
All right, everyone should be able to see our contact information on your screen, so if you have specific questions for any of us, you can feel free to connect with us via email. And for now, we will dive into the questions. So I will read off the questions, and then Joe and Les, whoever feels most comfortable or thinks it's most appropriate to field that question, should jump right in. Our first question asks, for the fictitious character that friends offenders, what photograph is used? Is it simply grabbed off the internet? And wouldn't this create a potential danger for the person who is in the picture?
I believe that would be my question. And we did not put a picture on our particular Facebook site for that various reason. We're still waiting for legal to give us an approval to use some generic photo from some particular association, but until we get that permission, we do not have a picture. So great question.
Yeah, this is Joe. It's a perfect question, and it's a very real risk. And I think some of those training resources that we pointed to would give detail about how to do that appropriately. One news item that I came across recently refers to a DEA agent who used a photograph of a woman for a social media profile. The woman was arrested previously for a drug charge, and the woman obviously eventually saw that and cried foul because this profile was created with her identity. So, you know, the federal government is reviewing how they use photographs to create fictitious IDs. So it's an issue across, you know, various levels of government. But I would refer folks to tread carefully and identify those, you know, get the training that they need to figure out how to do that the most appropriate way, because it is a risky proposition.
There is one of my staff found a website or a program that alters pictures, and they'll take 5 people and create a picture between those 5, so it really is not a particular person. But again, before we felt comfortable going down that road, we've not done that. So, and I would agree with Joe. You got to be this is an area that you want to be really careful on. So again, great question.
Our next question is related and asks, is there any kind of entrapment concern about using a fictitious character to friend offenders?
Well, it's certainly another area of concern. We, as you noticed by our particular policy here in Brown County, we don't converse with the offender, so we're not going to be able, we won't be in that situation. But yeah, I think there could be, and you know, law enforcement, however, does it all the time. They'll set up buys and supplies and do it quite often. So again, I think that's an area that you're going to want to talk to your legal team about to give some advice on how far, if you're going to create that covert site and go after folks, where do you draw that line? We just made the decision not to go down that road. I don't think we're ready yet, and I'm not sure if a lot of agencies are ready to go down that particular road, but maybe that is more the law enforcement role.
Yeah, and this is Joe, and I think that speaks to the different orientations that exist even among community corrections agencies. Some view themselves as more law enforcement oriented, and some more social worker helping oriented, and certainly those who view themselves on the helping end of the spectrum might feel like that is not an activity that's in alignment with their mission. So again, you know, as Les alluded to, it's something that the agency has to do some soul searching about and determine the best possible course.
Another webinar participant has asked whether you've had to field any inquiries from public defenders' offices or the court system regarding your social media policy and use of social media monitoring in community supervision.
This is Les. We have not had any push by the public defenders at all. We're very careful when we take something to court pulled off of a Facebook site or some comments made on Twitter or whatever that might be. again, it goes through several different hands, and people really look at it. Is this a strong violation? Is this worth taking them to court? Is there enough there for a solid violation? If there's not, then we're not going down that route. We feel real strongly that we're not going to take somebody who might have a picture of them sipping a beer, but no description, no nothing on it. We would never bring that to court because it would get thrown out in a heartbeat. If the person, however, had a very long description of the party last night at 4:20 and all these other people were there, and it's a real solid description, and we did a UA, and now we got a confession, you bet, yeah, we're going to court on something real strong like that. But at this point, no, we've not had any pushback from public defenders at all.
Great. Our next question goes away from the legal questions for a bit and asks, do you have any policy around harmful statements to self or others, and how staff should report that if they see it online?
We have a policy that's totally different. That, again, this is Les from Brown County. We have a duty to warn policy, so I think it would probably fall under that category. That if they saw something of they wanted, the person was going to harm themselves or harm someone else, that, yeah, they have the duty to make that full report. So have we had that? Yeah, I think we have had some cases where we've had those situations where, again, we're lucky enough that we're a smaller community that we can track down a social worker or a law enforcement officer to do a welfare check pretty quickly, and our law enforcement are excellent around here, and they'll follow through with that.
All right, a couple of questions I think we've started to touch on, but I'm going to read them anyway in case there's some additional information that you'd want to provide. One of those questions is whether information gathered on the internet can be used in court. And another is about the expectation of privacy. It sounds like one of the agencies represented by our participants has found that their attorneys want them to consider accessing social media sites as a search and need to then follow the applicable policies, reasonable suspicion, and so forth. Have you encountered any questions about that?
This is Les. As far as the search policy, that was certainly talked about and debated. Our legal team finally made the decision that no, it did not fall under that category because it was a public domain, and they felt we did not need to do a search, kind of like, well, they felt it did not fit under that category, so we didn't have to go that route. But yes, we have used information from Facebook. Actually, just very recently, we had a case where a young lady was threatening another female pretty seriously on the internet. So yeah, she was brought in and questioned, and there was an harassment restraining order filed afterwards. That information was used in a court proceeding against her. So yeah, we have used it. But again, it goes through several different eyes. It's not just the probation officer making the final decision on what's going to be turned into the courtroom. My eyes see it, my assistant director, one of our senior probation officers will always look at that information to get that second opinion. And again, being in a smaller county, we're fairly lucky. We can talk to the county attorney, call them up, say, here's what we got, here's what else we got, is this enough for a strong violation? And they're pretty good at saying, yeah, no, that you need a little more, or yep, let's go. Kind of depends on public safety and risk level. Where are we at with that public safety risk?
And this is Joe. As Les indicated, his jurisdiction determined that this does not qualify as a search, and that therefore bears the similar requirements. But other jurisdictions may do the same review and view it as a virtual search and want more more rigor behind it. So it's just important to know that every jurisdiction has to make that evaluation for themselves.
And that's why, as folks that are listening, or if they're going to, I'm assuming a lot of folks are grappling on developing this policy. I think if I would have done it over again, I would have brought our legal team in early on versus writing the policy, handing one copy to HR and one copy to the legal team saying, give us your feedback. I think looking back, I would have done it differently. I would have brought them to the table. I would have explained, here's what we want to do, and then got their feedback and their suggestions early on as we developed the policy. I think it maybe would have, took a lot less time than 2 years to develop it, but we would have got a chance to talk about some of these areas as we developed it. So had I done it again, I would have probably had a lot more meetings with them as I was working on this policy, as our team did, to create, other than just, like I said, handing it off to them and coming back with a whole bunch of red marks. And take this out, I'm going to reword this. And so that'd be my advice as people in the audience would be to bring them on much earlier on than after you write the whole thing.
We've gotten a great follow-up question to this discussion, and someone asked, what do you recommend about proving dates on posted photos? They've had a client post pictures with a handgun but are unable to prove when the picture was actually taken versus when it was posted.
And that's part of the problem. You're not going to, if that particular case, you're probably not going to be able to prove that photo. Those are those tough ones, because if there's nothing going along with it, no comments, no, you know, sometimes you can have a little bit stronger case if you get comments from other people saying, yeah, that was a wild party last night, or I can't believe you just bought that gun, or you get some very directive comments that can really help strengthen your case. But if you don't have those, you don't have them. Unfortunately, you're not going to be able to do a lot with that particular type of violation. Hopefully, you'll get something more down the road. I would certainly raise the risk level on that particular client, and I'd be watching that client certainly a lot closer. And that might be a candidate, depending on your jurisdiction, if you're allowed to do searches or not. We are allowed, and we might target them for a search if we had to. If we felt this was a real dangerous person and a high risk level, we might be going in and doing a tool.
Yeah, this is Joe. That's a great point. The photo itself might not be basis for a violation, but certainly regardless of when that photo was taken, that's important information that otherwise would not be available. And as Les said, you might intervene a lot faster in different ways based on that information, regardless of when that photo was taken. And frankly, regardless of whether that gun is real or a toy, or it really doesn't matter. If the supervisee is posting a photo like that, that's a concern.
Another person on the webinar has asked whether and how you inform people under supervision of the potential social media supervision activities.
This is Les. On our sex offender caseload, that's a condition of probation that they have to cooperate with probation in providing all Facebook or all social media websites, usernames, passwords, and the judge will also order that we have authority to access, possess, and investigate electronic devices, social media sites for the purposes of supervision and compliance. Non-sex offenders, we're probably not telling them, because we're basically just, if they're showing risky behaviors, they're a higher risk client, that's when the probation officers are hopping on the assigned computer and snooping around and seeing if there's anything in there they should be worried about. And many times they're not. They're not either. They're smart enough not to put it on there, but we all know some of our clients aren't quite that bright, that we do find some information that either raises our risk level or raises a need for us to increase our supervision level with that particular client. I hope that answers the question. I'm not sure. Joe, you want any more on that?
No, I think, just to chime in, it'll depend. For sex offenders, usually there's specific conditions around computer use in a general sense to include internet and social media. For others, some agencies interpret the general conditions of supervision as enough to warrant this type of search. So again, it's going to depend on the jurisdiction.
Great, and now we'll take a little bit of a different approach. We've gotten some wonderful questions asking about how you might consider using social media to look for positive behaviors and to promote some pro-social opportunities. So I'll lay out the two specific questions, and if you all want to take them in whichever order you prefer. The first person asked, do you look for positive behaviors in folks' social media postings? And the second question is about whether you use your own agency's social media page to post about access to pro-social opportunities, so reminders for T4C courses or jobs in the area.
We don't tell folks that we're out snooping around on their Facebook sites and their social media sites unless we really need to confront them about something we found on their Facebook site. So no, I would say that we would not do it in that particular way. We would certainly use motivational interviewing. We would certainly do our normal supervision discussions with clients and talk about positive things that they are doing, of course. We certainly want to promote what they're doing correctly, and we do so every day. But we don't tell people we're out snooping around on their Facebook sites unless we absolutely need to tell them, because we all know what's going to happen then. Those that are not doing correct things are going to change their passwords. They're going to lock it up. They're going to move on to a new username. So no, we don't tell them unless we absolutely need to. We're going to file that violation report, or there's a duty to warn, a duty that we need to contact them. No, otherwise we would not. Again, we decided not to have a local social media Facebook site for our agency. We don't have that, but we do have in our lobby. We have a large television that has tons of exactly what you talked about, job openings, how to get around in our city on the bus, where they can access. We put a lot of forms for our agency on our website. If they need AA slips, if they need to download X form, it's there. So yeah, in our lobby, with those that do come into our lobby, there's tons of that kind of information, that positive things about what's going on in our community, and so I hope that answered those two questions.
Yeah, this is Joe. I'm not aware of any agency who's using their outward-facing social media site for that purpose, but that's a great application. And agencies should strongly consider that. Job postings, treatment, housing, and any issue that would help the clients in their supervision, in their reintegration process. That's a perfect application. Too often we tend to look at technology as a hammer, a way to track or monitor or catch offenders doing the wrong thing. But technology is just a tool that could very easily be used to support positive behavior, to reinforce. Again, the real implications of Bless's comment about not wanting to tell the offender he's doing a good job because of what you found on social media is very relevant and important. But in terms of an outward-facing activity to make these opportunities known to the clients, that would be a great application.
Great. Well, we don't appear to have any more questions at this time, but I encourage everyone who logged in today to take note of the email addresses up on your screen. And please don't hesitate to reach out if you come upon any other questions. You can also always contact the National Reentry Resource Center for additional information, and we can certainly field out requests to the appropriate personnel. Thank you so much to APPA for partnering with us on this webinar, and to Joe and Les for sharing with us your expertise and your experiences. And of course, thank you to everyone who joined us online and on the phone for today's webinar. The links that were posted in the chat section, I heard a couple folks mention that they were having some trouble with them. It is entirely possible that the links are not working yet because the webinar is still going on. I probably should have noted that earlier. Once this recording is finished, the link should become active, and when it is active, you will receive an email that contains both the link to the recording, which will also include the slides, and also to the Brown County social media policy. If for any reason you don't receive that today or tomorrow, please feel free to contact any of us on this webinar or to contact me at the National Reentry Resource Center. Thank you again for joining us, and I hope everyone has a great day.
Thank you.